legal scope of the invention. Claims can protect the part or invention as a whole, so on a part or a portion of the invention can be used without infringing the patent. One should try to have broad claims as possible. But here it is something tricky. When one drafts broad claims, they might get objections from the examiner. Also, if you draft a narrow claim, you might give a scope for others to invent or claim around the invention. So you have to make a balance between that broad claim and narrow claim. Claim should define the subject matter which needs the protection. It should be very clear, concise, and must have description along with it. So whatever mentioned in the description, it should be covered in the claim. If it is not covered in the claim, that part of the description goes into the public domain without protection.